Welcome to this deep dive into the source material. Today, we're pointing our analytical lens at a really specific, highly consequential, and honestly fascinating corner of contract law: third-party beneficiary defenses.
It really is an incredible topic to get into.
I want you to imagine a scenario. You are buying a house, or maybe you're taking over a commercial business. As part of the deal, you sign a contract agreeing to take over a debt the seller owes to a third party. Seems straightforward enough, right?
Right, it's a very common transaction.
Right. What happens when that third-party creditor comes knocking on your door to collect, and you suddenly realize you've been, well, entirely scammed by the seller?
Oh, that is an absolute nightmare.
Or, worse yet, what if you find out the work that third-party creditor did in the first place was absolutely terrible? What defenses can you actually raise to avoid paying? Okay, let's unpack this, because the line between being legally on the hook and being off the hook is razor thin.
It is a razor-thin line, yes. And that is exactly why this deep dive into the source material is so crucial for anyone who signs contracts. First, we will examine the boundaries of liability when assuming a debt from another party.
Got it.
Second, we will look closely at how the exact phrasing of a debt assumption determines whether you can assert the original debtor's defenses against the creditor. What's fascinating here is that contract law in this arena is incredibly rigid.
Rigid how?
Well, it cares significantly less about broad ideas of fairness or common sense and far more about the precise text written on the page. We are going to see exactly how a single phrase can completely change your legal obligations.
That brings up a foundational question for this entire area of law. If a third party, let's say you, the buyer, assumes a debt, are you on the hook for the original promissory note that the first party signed, or just your brand new contract?
The general rule is quite clear and very strict. A party is not liable on a promissory note they did not sign.
Okay, that makes sense.
Their liability to the creditor does not magically spring from the original note itself. Instead, their liability exists exclusively through the specific terms of their new contract with the promisee, the original debtor.
So let me make sure I'm translating this right for you listening, because legal jargon gets dense quickly. The promisor is the new buyer, the one promising to pay. The promisee is the original seller. And the creditor is the bank or the contractor.
Exactly right.
So if I don't sign the original banknote, I am only bound by the literal words in my purchase agreement with the seller.
Precisely. If they didn't sign the instrument, the law looks only to the four corners of the assumption agreement they actually did sign.
That distinction is perfectly illustrated in a foundational case from the 1950s. Let's analyze Rouse v. United States. First, what are the legally dispositive facts?
The facts here involve a chain of transactions that are very common in real estate. A woman named Bessie Winston gave a promissory note to Associated Contractors, Inc. to pay for a heating plant in her house. This note was guaranteed by the FHA, the Federal Housing Administration, and then the contractor endorsed it over to a lending bank. Later, Winston sold her house to our defendant, Mr. Rouse.
Right.
In their contract of sale, Rouse agreed to assume certain debts, including a clause where he explicitly agreed to, and I quote, assume payment of $850 for heating plant. Crucially, Rouse never signed the original promissory note.
That is a crucial detail.
Very much so. Eventually, Winston defaulted, the U.S. government, having guaranteed the note through the FHA, paid the bank, took an assignment of the note, and sued Rouse for the $850.
And Rouse fought back.
He did. He raised two distinct defenses. First, that Winston fraudulently misrepresented the condition of the heating plant to him when selling the house. And second, that the original contractor didn't install the heating plant properly.
And what did the trial court say?
The trial court struck down both of his defenses, basically telling him he had to pay regardless.
Wow. So they just completely shut him down on both fronts. That seems brutal for Rouse, holding the bag for a faulty heater and a fraudulent seller. And what was the core legal issue?
The appellate court had to resolve two precise legal questions. First, can a promisor who assumes a specific debt assert the promisee's fraud against the assignee creditor?
Okay, so can Rouse use Winston's scam as a shield against the government? What's the second?
And second, can that same promisor assert the promisee's defense against the original creditor's performance?
Got it. Can he use the contractor's bad work as a shield? Those are the stakes. What rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
The court applied black-letter law that we can break down into two distinct rules. Rule 1 governs the promisor's defenses.
Okay.
It states that a promisor who agrees to pay a promisee's creditor can assert against the creditor any defense the promisor has against the promisee. This rule has two elements. First, a contract assuming debt, and second, a valid defense against the promisee, such as fraud.
That seems straightforward. And the second rule?
Rule 2 governs specific debt versus general liability. It states that if the promise is to pay a specific debt sum, it is legally immaterial if the promisee actually owed that amount to the creditor.
Interesting.
This rule also has two elements. First, a promise to pay a specific sum, and second, an attempt by the promisor to use the promisee's defense against the creditor's performance.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element of Rule 1, contract assuming debt?
For this element, the sub-issue is whether Rouse actually had a contract that assumed a debt, establishing his liability since he definitively didn't sign the original note.
Right.
The sub-rule is that liability must arise from the explicit terms of the contract between the promisor and promisee. Looking at the application of the facts, Rouse explicitly agreed in the written contract of sale to assume an $850 payment for the heating plant.
But not the note itself.
Exactly. He was not liable on the note itself because he didn't sign it, as dictated by the D.C. Code and Negotiable Instruments Law, but his specific contract with Winston explicitly created this new obligation. Therefore, the court concluded that this first element is clearly met.
Understood. He didn't sign the bank's note, but he signed the contract of sale with Winston, so he's tethered to that document. Now, what about the second element of Rule 1, valid defense against the promisee?
The sub-issue here is whether Rouse can use his allegations of Winston's fraud as a valid shield against the United States, who is acting as the assignee of the creditor.
Because he claims she lied about the heater.
Right. The sub-rule states that one who promises to make a payment to the promisee's creditor can assert against that creditor any defense they could assert against the promisee. Applying the facts, Rouse alleged that Winston fraudulently misrepresented the condition of the heating plant.
So he carries his defense with him.
Yes. Because the law dictates that a promisor steps into this arrangement, retaining their rights against the person who tricked them, Rouse is fully entitled to use Winston's fraud as a defense against the U.S. government. The government stands in the shoes of the corporation.
And Rouse can raise the exact same fraud defense against them.
He can. The court concluded this element is met, meaning the trial court actually erred when it struck down his first defense.
Okay, that makes perfect sense to me. If the seller lied to you to get you to sign the contract, the government or the bank can't just ignore that lie when they try to collect. You carry your defenses with you. But that was only his first defense. Okay, let's look at Rule 2. How did the court apply the first element? Promise to pay a specific sum.
The sub-issue here is determining the exact nature of the liability Rouse assumed. Did he assume general liability or a specific quantified debt? The sub-rule is that courts must look to the precise language of the assumption agreement.
To see if it names a definitive monetary figure.
Exactly, rather than a general discharge of an obligation. Applying this to the facts, the court closely scrutinized the text of the sale contract. Rouse did not agree to a broad statement like, "I will discharge whatever liability Winston has to the contractor."
Because he named a number.
Right. He agreed to assume a highly specific numerical sum, $850 for heating plant payable $28 per month. The court concluded this element is met. It was undeniably a promise to pay a specific sum.
I see exactly where this is going, because he literally wrote down $850 instead of whatever she owes. The trap is set. And the second element of Rule 2, attempting to use promisee's defense against creditor.
The sub-issue is whether Rouse's second defense, that the contractor did a poor job installing the heating plant, is legally viable given his promise to pay a specific sum. The sub-rule dictates that if a promisor agrees to pay a specific sum to a creditor, it is entirely legally immaterial whether the promisee is actually indebted to the creditor for that full amount.
The promise is absolute as to the number.
Yes. Applying the facts, Rouse tried to argue that he shouldn't have to pay because the contractor's work was unsatisfactory. Essentially, he was trying to borrow Winston's potential defense against the contractor.
But he promised Winston a flat $850.
Exactly. The law says he cannot look behind that number. It doesn't matter if Winston only truly owed the contractor $400 because of the shoddy work. Rouse promised $850. The court concluded that Rouse cannot raise the contractor's bad performance as a defense. Therefore, the trial court was absolutely correct to strike this second defense.
That is incredibly rigid. So literally because he wrote the number, he's trapped paying for a broken heater, even if the work was garbage. And after analyzing all the elements, what was the court's final conclusion?
Synthesizing the elemental analysis, the appellate court's final holding was to reverse and remand the judgment. The court ordered the reinstatement of Rouse's first defense, the fraud committed by Winston, because a promisor can always assert the promisee's fraud against the creditor.
But the bad installation.
The court simultaneously upheld the striking of his second defense regarding the contractor's faulty installation, because a party who assumes a specific monetary debt cannot borrow the promisee's defenses against the creditor's performance. He wins on the fraud, but loses on the shoddy workmanship.
Here's where it gets really interesting, because the law here can feel a bit abstract, a bit like a logic puzzle, until you put it into a real-world, slightly graphic scenario.
Graphic scenarios always help the rules stick.
I want you, the listener, to picture this. Imagine you decide to buy a commercial meat packing plant from a notoriously shady owner named Winston.
Okay.
As part of the purchase agreement, you sign a contract assuming a very specific $10,000 debt that Winston owes to a local meat supplier. You get the keys, you move in, and immediately you discover that Winston had completely hidden a massive, rotting rat infestation behind the walls of the facility.
So clear, undeniable fraud by Winston.
Clear fraud. But it gets worse. Simultaneously, you start looking at the inventory logs and realize the meat supplier, the creditor you now owe $10,000 to, had actually been delivering rancid, maggot-infested meat to Winston for months before you even bought the place.
Disgusting.
Truly. So you have fraud from the seller and a total disgusting failure to perform by the creditor.
That is a wonderfully visceral hypothetical.
Yeah.
And it perfectly illustrates the stark boundaries of Rule 1 and Rule 2 that we just analyzed. Let's apply the law to your meatpacking plant.
Let's do it.
Under Rule 1, because Winston defrauded you by hiding the rotting rat infestation, you have a valid defense against the promisee. The law allows you to raise that exact defense against the meat supplier to avoid paying the $10,000.
Because I was tricked into the contract of assumption in the first place.
Right. You were tricked by the seller's fraud, so the rats save you. However, let's look at the maggots under Rule 2. Because you explicitly promised Winston you would pay the specific sum of $10,000 to the supplier, you cannot argue that the supplier was delivering maggot-infested meat to Winston.
Wait, really? Even though the meat was rancid?
Yes, really. You didn't write a contract that said, I will pay whatever Winston legally owes the meat supplier for valid goods. If you had written that, the maggots would be a great defense. You could step into Winston's shoes and fight the supplier.
But I didn't. I promised a flat, specific $10,000.
Exactly. The law says it is completely immaterial if Winston actually owed that money given the rancid meat. Therefore, the maggots do not save you. Only the rats do.
So what does this all mean? When you are looking at a messy contract dispute involving assumed debts or sitting down to take a law exam on this exact topic, how do you actually parse out who owes what to whom? Could you distill this into a practical checklist for us?
Absolutely. Whether you are navigating an exam question, spotting issues in a real estate deal, or dissecting a real-world dispute, you need a step-by-step diagnostic checklist to keep these doctrines straight.
Let's hear it.
Step 1. Check the signatures. Did the third party actually sign the original promissory note? If yes, they are liable on the note itself. If no, their liability doesn't exist on the note, and you must move immediately to the four corners of the contract of assumption.
Right. And step 2.
Step 2. Identify the origin of the defense. Who wronged the third-party promisor? Was it the promisee, like the seller of the house or the business who lied to them? Or was it the original creditor, like the contractor doing a bad job, or the meat supplier delivering bad goods? You have to map the relationship.
I mapped it out. Okay. Step 3.
Step 3. Apply the promisee defense rule. If the promisee committed fraud, misrepresentation, or a breach of contract against the promisor, this defense is valid against the creditor. The promisor can use the promisee's bad acts to shield themselves from the creditor's claims.
The rats save you?
The rats save you. Then, step 4. Analyze the exact language of the assumption for creditor defenses. Look incredibly closely at the written words. Did the promisor agree to pay a specific debt or sum, like $850 or $10,000? Or did they agree to a general assumption, like to discharge whatever liability exists?
And finally, step 5.
Step 5. Final determination. If the contract names a specific sum, the promisor absolutely cannot use the promisee's defenses against the creditor's poor performance. They're locked into the number. If, however, it is a general assumption of liability, then they can step into the promisee's shoes and fight the creditor's claim based on poor performance.
It all comes down to the literal ink on the page. It's almost terrifying how precise you have to be.
It is terrifying. If we connect this to the bigger picture, it reveals a profound truth about contract law and commercial systems. The law is designed this way for a very specific reason.
To protect the banks.
Essentially, yes. It rigidly respects the exact words written on the page to isolate liabilities and preserve the flow of commercial debt. Think about the assignee in the Rouse case, the bank, and eventually the United States government. They rely on the certainty of specific numbers to buy and sell debt.
Because if every single person who assumed a specific debt could suddenly refuse to pay by arguing about the quality of the original contractor's work,
The entire secondary market for debt would grind to a halt. Lenders wouldn't be able to trust the paper they hold. They'd have to inspect every heating plant or meat delivery before buying a loan.
that would be impossible.
Right. By separating these defenses and focusing strictly on the text, the law ensures that commerce can function smoothly and efficiently, even if it feels incredibly harsh in individual circumstances like Rouse's.
It really leaves you with a haunting realization about the power of drafting. Think about it. Imagine if Rouse's contract had simply said, Rouse assumes Winsta's liability for the feeding plant, instead of explicitly naming the $850. Just those few missing words.
It changes everything.
It really does. If he had phrased it generally, it would have entirely changed the outcome of the case. He would have been allowed to fight the contractor's shoddy work and potentially avoid paying for a broken system altogether. It leaves you wondering, how many people out there are trapped paying for broken things right now simply because they wrote down a specific dollar amount on a piece of paper instead of a general assumption of liability?
Too many, I'm sure.
It's a stark reminder to read every single word. Thank you for joining us for this deep dive into the source material. We hope it encourages you to look a little closer at the assumptions in your own contracts and to never take a specific dollar amount for granted. Keep questioning, and we'll catch you next time.